So our next speaker this evening is Professor Jonathan Mitchell, who is a professor at George Mason Law School, where his research focuses on national security law, criminal law, and procedure, and federal habeas corpus.
My claim is that the Supreme Court of the United States can and should reverse state Supreme Court rulings solely on state law grounds in at least some situations. This is contrary to the Supreme Court's current practice. The justices will never reverse a state Supreme Court ruling solely on state law grounds. They will, on some occasions, reject a state Supreme Court's interpretation of state law in the process of enforcing federal rights against the states. Probably the most famous example of this was NAACP ex rel. Patterson against Alabama, where the Supreme Court rejects the Alabama Supreme Court's interpretation of state procedural law that the state Supreme Court had misinterpreted to thwart the NAACP's efforts to vindicate a federal constitutional claim. But all of these sorts of cases, like NAACP and other cases from the adequate and independent state grounds jurisprudence, go on to hold, after rejecting the state Supreme Court interpretation of state law, that the state court also has violated some provision of federal law. So the justices will never use state law reversals as a means to avoid the need to decide the federal law claim in the case, and that's what I'm proposing here. And the justices' reticence to reverse solely on state law grounds is what I refer to as the Murdock Regime. It's a legacy of the Supreme Court's 1873 decision in Murdock against City of Memphis, which held that the court lacked jurisdiction, in the justices' words, to review a state Supreme Court interpretation of state law. I reject that absolutist view, both on doctrinal legal grounds and also on consequentialist grounds. I propose a different regime that allows such state law reversals in a limited subset of cases. These are cases where a state law reversal would allow the justices to avoid a ruling, a reversal that would otherwise rest on a novel and controversial federal constitutional pronouncement. It's a way to use state law reversals as a means of constitutional avoidance. First, there's no external legal barrier that prevents the Supreme Court of the United States from reviewing or reversing a state Supreme Court's interpretation of state law. Article 3 of the Constitution gives the Supreme Court appellate jurisdiction over the state Supreme Courts in any case that falls within the enumerated cases listed in Article 3. And all that Article 3 requires for the Supreme Court to have jurisdiction over a case is that the case present a federal claim. In like manner, 28 U.S.C. Section 1257, which is the statute that Congress enacted to govern the Supreme Court's appellate jurisdiction over the state courts, provides that the Supreme Court will have jurisdiction over any final judgment or decree issued by the state Supreme Courts, so long as that judgment or decree presents a federal claim. The federal claim is the gateway by which the Supreme Court is empowered to review the entire case. It's a necessary condition for jurisdiction, but it does not limit the court's jurisdiction to reviewing that one federal law issue. The court could reverse a state Supreme Court on fact-finding grounds, for example, and the court also could review and reverse the state Supreme Court's interpretation of state law if it so chooses. It can resolve the case on any means it sees fit, once there's a federal claim established. So the proper question is when and the circumstances in which the Supreme Court should use its discretion and use the writ of certiorari to exercise this prerogative that it undoubtedly has. The Supreme Court's categorical unwillingness to consider state law reversals is in real tension with the court's oft-stated desire to avoid resolving federal constitutional questions unless absolutely necessary. When state Supreme Courts issue rulings that the justices regard as questionable or biased or misguided, the status quo Murdock regime forces the justices into a binary choice. They can either allow the state Supreme Court ruling to stand, or they can reverse on federal constitutional grounds. And when the justices find the former option to be intolerable, the illusion that they lack power to reverse solely on state law grounds causes them to issue unnecessary and often highly questionable interpretations of federal constitutional law in the process of reversing that state court ruling. There are many examples of this. Probably the paradigmatic case is Bush against Gore, but I want to talk about other cases that have less of a partisan implication. Think of Boy Scouts against Dale. This is a 2000 ruling from the Supreme Court. The New Jersey Supreme Court had earlier held that the Boy Scouts qualified as a place of public accommodation under state anti-discrimination statutes. This was a dubious and questionable interpretation of the meaning of place of public accommodation. But the justices would not even consider reviewing that state law issue. When the Boy Scouts petitioned for certiorari, they raised a First Amendment objection to the New Jersey Supreme Court's ruling. That First Amendment claim was enough to give the justices jurisdiction over the entire case, but because of Murdock, the justices wouldn't review the state Supreme Court's interpretation of state law. They were forced into choosing between affirming the New Jersey Supreme Court ruling, which forced the Boy Scouts to accept homosexuals as scoutmasters, or concocting some First Amendment right for the Boy Scouts to discriminate against homosexual scoutmasters and entrenching that constitutional pronouncement for all time. It can be reversed only by a federal constitutional amendment or perhaps by new Supreme Court appointments, justices that might reverse Boy Scouts against Dale. Other examples can include New York Times against Sullivan, where the Alabama Supreme Court adopts a highly questionable application of the common law of defamation, or the punitive damages cases, BMW against Gore, which reviewed the Alabama Supreme Court's application of state punitive damages law. All these cases caused the justices to create new federal constitutional doctrines as a means to reverse state Supreme Court rulings that they deemed unacceptable. Now, these Murdock-induced constitutional pronouncements will often be costly substitutes for a prerogative to issue reversals that rest solely on state law grounds. First, they produce nationalized and entrenched rulings that the political branches are powerless to change, except by a constitutional amendment or a new Supreme Court appointments. And this significantly increases the error costs of the court's rulings if the justices' views turn out to be mistaken. Now, a state law reversal, by contrast, would affect only one state, and it would preserve space for democratic institutions to enact different policies in the near or distant future. In addition to this, these novel constitutional doctrines that the court announces in cases such as Boy Scouts and Bush against Gore and BMW against Gore and New York Times against Sullivan and other similarly situated cases, they promise to impose very large decision costs on future courts because they greatly complicate federal constitutional doctrines. Just think of the ramifications that Bush against Gore will have for every election dispute. Future election disputes will allow litigants to raise equal protection claims to essentially any sort of recount. And BMW against Gore creates a novel constitutional common law of punitive damages that courts will have to apply, in addition to state law limits on punitive damages awards. So I argue in the paper the Supreme Court could mitigate and avoid these problems, minimize the sum total of decision costs and error costs associated with their rulings by recognizing an option to reverse certain state Supreme Court rulings on these minimalist state law grounds. There's no need for the court to trundle out the heavy artillery of federal constitutional law every time it seeks to reverse an unacceptable state court decision. Finally, we need to consider whether there's anything that could motivate the justices to adopt this proposal. I mean, one might think once the justices have 5 votes to reverse a state Supreme Court on federal constitutional grounds, why on earth would they want to reduce the impact of their holding by resting their decisions solely on state law grounds? And I believe there are at least 3 mechanisms that could induce the justices to use state law reversals in some of these cases. First is the idea that there's a veil of uncertainty every time they announce a new federal constitutional doctrine. Right? A court majority cannot predict or control how future Supreme Courts might apply doctrines like the equal protection holding in Bush against Gore or the First Amendment right that was recognized in Boy Scouts against Dale. We saw law schools try to use the Dale holding to keep military recruiters off campus. We saw justices use Brown against Board of Education to block the Seattle School District's efforts to achieve racial balancing in schools back in 2007. This might make the justices find a state law reversal more attractive in the sense that it will not open up the door for possible mischief if they have to use a federal constitutional pronouncement to reverse a state Supreme Court. Second mechanism is what Jan Elster